Hi, welcome to Case Briefs with Megan. Let's make this case brief. Megan, it's been like a month. Where have you been? Let me tell you. I'm in the spring semester of my third year of law school, but it's night school, so I'm not finished just yet. So I've got more time to go. It's just been a lot. I also got a new job and then proceeded to quit that job because I got my dream job working for a media company, so I guess I'll be working in entertainment soon, which is like super fucking cool. I've also just been training, and now I am in physical therapy and still training at the same time, because the whole reason I even started this channel was so that I could do my training for the Boston Marathon. So here we are. I've been doing that on the side too. I also really hadn't been sleeping for more than 3 or 4 hours a night for 2 weeks because I had a mouse infestation in my apartment, and I figure we can turn this into a learning lesson with the case Javins versus First National Realty Corp, which talks about the warrant of habitability. You'll learn this in your property law course. So let me give you the lowdown. So First National Realty Corporation owns an apartment building, or a series of apartment buildings in the DC area. And actually it's the Realty Corporation that's bringing all of this to court. They're bringing a couple of their tenants to court because they're not paying rent. And what's a corporation always going to want? They're always going to want their money is what they're going to want. And actually the 3 tenants, including Javins and a couple of her other co-tenants, admit that, yeah, we haven't been paying rent, but we have a really good reason. So Javins and her co-defendants actually took a look at the District of Columbia's housing codes, which kind of set the standard for what you're able to expect in every single apartment that you walk into in DC. There's one for each and every city, there's one for each and every state, that all landlords or whoever owns the apartment building that you live in must follow. And Javins and her co-tenants actually have a lot to complain about. They're like, if you walk into our apartment, you'll see a lot of DC housing code violations. You'll see rat infestations. You can't use the toilets. There's no hot water. There's no heat. There's peeling paint. So imagine if you have a family living in one of these apartments and a kid eats paint. Not a good combo. And what this case brings up is something called the warrant of habitability. What this case essentially holds is that you are entitled to certain rights as a tenant if you're living in an apartment, because when you're on a lease, technically you're on a contract. You're contracted to live in that place for a certain amount of time. And essentially, when you sign your lease, you have what is called an implied warrant of habitability, which means that it's implied that you should be able to reasonably inhabit your apartment with hot water, with heat, and certain other amenities. What the court specifically mentioned is that when Javins and her co-tenants moved into these apartments, it's not like there were these violations when they moved in. There was no reason to believe that you would find mice or broken toilets in the apartment. Otherwise, people probably wouldn't move into the apartment. What this warrant of habitability basically implies is that if you're paying your rent, you're going to expect your premises to be kept in the same sort of condition as when you first signed on for that lease. What this case also essentially says is that as long as the tenants are continuing to pay the same exact rent price, they would expect the premises to stay in the same condition, not that they would have to deal with broken toilets and no heat along the way. This is also a really cool case which brings up your rights as a tenant versus a landlord, because the courts recognize that when you're a landlord, you tend to have a little bit higher bargaining power between yourself and your tenant. Your tenant can't really demand that you make their apartment into like a 5-star luxury hotel, right? All that they ask in this implied warrant of habitability is that you just keep the apartment in the same sort of condition that they started living in. The court also brings up a really good point. This would be a completely different case if First National Realty had no idea about any of the rats or the defects or the no heat or anything, but they had noticed that all of these problems were arising. And the court wants to let their landlord kind of get a chance to do some good, fix the mistake. They all deserve that right. This case also goes crazy when it says things like the tenant's obligation to pay the rent depends upon the landlord's performance of his or her obligation. So if your landlord is not taking care of your apartment or taking care of the premises, the tenant really doesn't have any other remedies besides not paying their rent until something is done. So there you go. If you live in an apartment, you do have basic rights to heat and hot water, and even no mice if you don't want them. And if you learn anything from this case, just know that me and mice are mortal enemies now.